Hi, this is Professor Unmac, and I know that not everybody who has signed up for this class has taken Poli-Sci 301, so I thought I'd do a quick, although I can't say hello in less than 5 minutes, so it'll probably not be as quick as it could be. I'm going to do a quick discussion about the Constitution, the Bill of Rights, and judicial review. This is one of three videos that I've asked you to watch for this first orientation week of class. So the first thing I wanted to talk about is how the federal judicial system is established in the Constitution. So Article 3 of the U.S. Constitution establishes the Supreme Court. It's actually a really short article, and partly that's because the framers of the Constitution knew what a court was. They knew they had to have courts, but they didn't spend as much time thinking about the court as they did thinking about the presidency or how Congress should be established. But Article 3 actually does establish that there will be a Supreme Court. It doesn't say how many justices will be on the court. It's been 9 for many, many, many decades now, but the Constitution leaves that up to Congress to decide how many judges there are. In Article 1 of the Constitution, so Article 1 creates the legislative branch, or Congress. Section 8 of Article 1 is where Congress's enumerated or listed powers are found. And one of those powers that's given to Congress is the power to create courts below the Supreme Court. So the U.S. federal court system is actually 3 layers of courts, and the trial courts and the middle layer of appeals courts were all created by Congress. Congress also decides through legislation that would be signed by the president how many judges there are, where the courts are located, etc. So Article 1 gives Congress a lot of control over the structure, ultimately, of the United States court system. Article 2 of the Constitution specifies the process by which a person can be made a judge. That power is given to the president initially to nominate a judge when there is a vacancy on the federal court. So not only Supreme Court justices, but also appeals court justices and all of the federal trial court judges are all put in place essentially the same way. They're nominated by the president, and then they go through a hearing process and have to be confirmed by or approved by a majority of the United States Senate. So it's kind of a 2-stage process. This is the current United States Supreme Court. Judges on the Supreme Court serve for a period of good behavior. This is the most recent. I'm not very good at PowerPoint, but I learned how to do that, so I thought that was kind of funny. This is the most recent person who joined the United States Supreme Court. His name is Brett Kavanaugh. His confirmation was very controversial. So far, Donald Trump has had 2 nominees. This is Neil Gorsuch, and this is Brett Kavanaugh. The Chief Justice of the United States Supreme Court is John Roberts. Therefore, this court is known as the Roberts Court and will be known as the Roberts Court until John Roberts is no longer Chief Justice, regardless of what happens to these other 8 justices. So where are our rights found in the original Constitution? Most of what we're going to be studying this semester is the Bill of Rights, the first 10 amendments to the Constitution, and the 15th Amendment, which deals with voting rights, the 19th Amendment, which we're just celebrating the 100th anniversary of the women getting the right to vote in the 19th Amendment, and of course the 14th Amendment, which is really, really important for civil rights and for treating people equally, trying to avoid discrimination and that kind of thing. But there are a couple of rights that are actually found in the original Constitution. So you can get a little bit of a feel for what was going on at the time and the sorts of things that the framers were concerned about, things that maybe happened under the king before we became a country, and then things that were maybe happening at the time that they felt were important enough to put into the Constitution originally. They didn't put free speech, freedom of the press, freedom of religion, etc. But they did find it important to put a few rights into the Constitution. So the first thing is related a little bit to religious freedom. The Constitution bans religious tests for office. So generally speaking, what that means is a state, well, the federal government can't, and now states can't either, um, require that you belong to a particular religion in order to run for office, or that you profess religiosity in order to run for office. It may be that people won't vote for somebody if they belong to a certain religion or if they profess to be an atheist or something like that, but there are no religious tests for office allowed in the United States. We also have a right to habeas corpus that's listed in the Constitution as one of our rights. Habeas corpus is essentially related to making sure that people are not held without trial. Habeas corpus, I remember my Latin, literally means produce a corpse. You have to show that there's evidence to hold people for trial. And we're not going to talk a ton about that in this class, but it's there in the Constitution. We also don't allow what are called ex post facto laws. Ex post facto laws are laws that would go into effect today, but would have a provision in them that would allow people to be punished for doing that action that's now illegal before it became illegal. That would be an ex post facto law. We don't allow that. So when we pass laws, it means they go into effect from now on, not you can't be punished for something that wasn't illegal when you did it. The basis of our law is, generally speaking, you can do whatever the law does not say you can't do. So there we don't allow ex post facto laws. And we also don't allow bills of attainder. These, it's mostly a historic element. We don't hear very much about bills of attainder anymore, but essentially a bill of attainder would do one of two things. One, it would essentially punish not only the person who committed a crime, but allow sort of for punishment of their family as well. But it also, a bill of attainder, more specifically in terms of the general population, it would be a bill that creates a law that also specifies that somebody is guilty of violating the law. So if we have a law that says you can't break into people's houses and take their stuff, that's okay. We can have laws against robbery. But a bill of attainder would be something along the lines of this group of people is now found guilty of breaking into people's houses and stealing their stuff in the law itself. Generally speaking, we require that people be found guilty by the judicial process, not the legislative process. So I want to talk a little bit about why the Bill of Rights came after the Constitution was written, and one other thing that the Anti-Federalists, the people who oppose the Constitution, were concerned about that has to do with courts and rights and liberties that we're going to be talking about over the semester. The first thing that the Anti-Federalists were concerned about was that the Constitution lacked a Bill of Rights. There was no mention in the body of the Constitution when it was being debated by the 13 states, when they were deciding whether they were going to ratify this Constitution or make it the law of the land. The Anti-Federalists were concerned that it didn't protect people's individual liberties. There was no mention of free speech. There was no mention of a free press. There were no provisions having to do with fair trials and protection of people's property and that kind of thing. So the Anti-Federalists were concerned about that. They were also concerned about what we call judicial independence, and that is the fact that judges are not elected, they are appointed, and they serve essentially life terms. They serve for a period of good behavior. It's very difficult to, quote unquote, fire a judge at the federal level. They can be impeached, but that is a very, very, very rare phenomenon. There's never been a justice on the Supreme Court, for example, who's been impeached. And the framers were, the Anti-Federalists were concerned about that. One, They thought that the judges would be susceptible to bribery, that the judges, because they would be so independent, would be susceptible to influence by wealthy or big corporations. This is a meme that reflects some Democratic concerns about Republican justices on the court. I'm sure there are memes that talk about the Democratic justices too. We'll try to bash everybody equally, but I thought this was actually kind of funny. And then the other thing that the anti-federalists were concerned about was that because the judges would be independent, they might have too much power. And so kind of what the anti-federalists were talking about many years ago, over 200 years ago, was a concern that a lot of Republicans have about an independent judiciary today. You hear it mostly from Republicans, this concern that judges will engage in what they call legislating from the bench, that rather than ruling narrowly and justifying their decisions on specific parts of the Constitution, that the justices might read their own opinions or read their own policy preferences into the Constitution and interpret the Constitution in a way that was not intended by the framers. Next week, we're going to talk a lot about the different theories about how the Constitution should be interpreted, but I just wanted to point out that some of the arguments that we're still having about the court were brought up more than 200 years ago by the anti-federalists. Of course, they lost the argument about judicial independence. The Federalists actually objected to including a Bill of Rights. The Federalists were the people who supported the Constitution, and they had to defend the lack of a Bill of Rights. So Madison mostly does this. He says the Constitution creates a limited government, and since the Constitution, for example, Congress doesn't have the power to regulate the press, it's not really necessary to enshrine freedom of the press in the Constitution because Congress doesn't have the authority to regulate that aspect of our lives anyway. Same thing with freedom of speech, the right to bear arms, that kind of thing. His other concern, and this will actually come up later in the semester when we talk about the right to privacy, Madison was concerned that any list of rights that you put in the Constitution would be necessarily incomplete. And the concern was that if you list some rights as rights that are protected, people might think, people in power who are passing legislation in particular, might think that those are the only rights that people have. And so if you left off something that was really important, it might be more difficult to protect that right in the future. But the anti-federalists wanted a Bill of Rights. They argued that there's a tendency for people in power to abuse their power, and so why not put specific restrictions on the use of power right from the very start? The state constitutions all had bills of rights. So the anti-federalists argued, why should the federal government be given essentially more power over people's lives than the state constitutions allowed state governments? If it was important to protect religious liberty and freedom of the press and fair trials at the state level, why shouldn't the federal government be restricted in the same way? And because the Constitution gives the federal government way more power than it had under the Articles of Confederation, the anti-federalists were really worried about the abuse of federal power. And ultimately, the Federalists gave in. This is a little cartoon that sort of illustrates this, where they finally said, okay, if that's what it's going to take to get you to vote yes on the Constitution, then vote yes, and we promise we'll put a Bill of Rights in the Constitution right off the bat. Because the argument that won the day was that people are entitled to a Bill of Rights. When the Constitution was adopted, right after that, like in the first Congress, there was a slew of amendments proposed. I think there were more than 200 amendments proposed to the Constitution. Ultimately, 10 of them got adopted all at the same time. Those are what we call the Bill of Rights, and we'll be studying those a lot this semester. So the last thing that I wanted to talk about is how Hamilton, Alexander Hamilton of Hamilton fame. He is the person who wrote the Federalist Papers that defended the court's independence. And we're not going to talk a ton about judicial independence in this class, but I wanted to just kind of introduce the concept. The fact that judges are not elected gives them some cover from being pressured to make decisions one way or the other. Hamilton pointed out something that is actually true about the court, that the court doesn't have any proactive power. So, for example, if Congress passes a law, the Affordable Care Act, or a tax cut, or a tax increase, or a stimulus package, or any kind of law that Congress might pass, the court can't just strike that law down or rule that it's constitutional. They have to wait until somebody challenges the law, until it goes through the lower courts, until it goes through the appeals courts. The Supreme Court doesn't have the authority to just step in to a political debate and make a ruling when there's no case before them. And so Hamilton was concerned that if the judges were not independent, they would have no power at all. The other thing that Hamilton pointed out that is actually true is that the court relies on the other branches of government to implement their decisions. So, for example, when the Supreme Court ruled that flag burning is protected speech, well, that essentially was a Supreme Court ruling. But the Supreme Court doesn't implement its decisions. So can you imagine what would happen if states decided they were going to continue to punish people for burning the American flag? Or when the court ruled that states may not ban same-sex marriage, what might have happened if more than just a county in Kentucky had said, well, we're going to ignore the court's ruling and we're going to deny marriage licenses to same-sex couples anyway? That can make the court, if it happens, it could create a constitutional crisis around the authority of the court. And so over time, the court's actually been pretty cognizant of that. And so a lot of they do make really, really important decisions that are sometimes extremely controversial. But given what they could do, it's pretty amazing how small a group of cases they decide every year. The other thing that Madison pointed out, and this is one of the biggest arguments in favor of judicial independence to this day, there are a lot of people who think that we should change the Constitution to make the judges more beholden to political leaders or to voters. And the people who favor judicial independence make the argument that it is, in a lot of ways, the very independence, the ability of the court to go against public opinion or to go against what the powerful want them to do, that has protected people's liberties and expanded people's rights over time. So, for example, a lot of people point to Brown versus Board of Education, which banned segregation in the schools, and would argue probably pretty convincingly that if the justices on the Supreme Court in the 1950s had known that if they ruled against segregation, they would lose their jobs, they might not have done it. So part of the job of an independent judiciary is to protect the unpopular and to make sure that even criminals, for example, get a fair trial, that the law treats people equally. We have a ways to go before we are a more perfect union, but judicial independence, Hamilton points out, and most modern scholars who favor judicial independence would point out, that if you want to protect people's liberty, you really need some body who doesn't have to look out for their own political job in order to protect people's liberty, or they might not be willing to do it if that's not what the majority wants. So let's talk a little bit about judicial review. I have a video that I want you to watch about Marbury versus Madison. So I'm just going to introduce this concept. Most of you, I'm sure, have heard of this concept before, but it really is what we're going to be studying most of the semester, is how the Supreme Court engages in judicial review and what they've done over time with regards to our rights and liberties. The interesting thing about judicial review is that there's nothing in the Constitution that gives the court the power to engage in judicial review. The Supremacy Clause binds judges to follow the Constitution. This Constitution, it says, and the laws of the United States, which shall be made in pursuance thereof, that means laws passed by Congress, shall be the supreme law of the land, and judges in every state shall be bound thereby. So there's an implication in the Supremacy Clause that everybody has to follow the Constitution, but it doesn't specifically say that the Supreme Court gets to decide what the Constitution means and what's allowed under the Constitution and what's not allowed under the Constitution in the event of a conflict. So judicial review is the power of the Supreme Court to interpret the Constitution and determine whether a law passed by Congress or passed by a state court, or something like a decree by a governor that everybody has to wear a mask, or an executive order by the president that this pot of money is going to be transferred over to build a wall. Those kinds of things can all be challenged in the court, and the court can exercise what we call judicial review to determine whether or not that law or that action by a government entity is something that the Constitution allows. It is an awesome power, and that's what we're going to be studying mostly this semester. The Supreme Court actually gave itself that power, in a case called Marbury versus Madison, probably the most important case the court has ever decided in terms of the power of the Supreme Court. It was decided in 1803, and I have a video, not that I put together, it's actually much better than the ones that I put together, that I've asked you to watch. It's only about 4 minutes long. So thanks for watching this video, and I will stop now.